cautions and practical points to remember. I have written these points with regard to 138, but they will cater in every way, in every kind of matter. Now, a complainant's counsel is the privileged master of his case. Why do I say so? Because you are going to decide how you want to streamline your matter. You must know you are the privileged master. You can decide. The defense evidence, the defense leading party cannot bring documents which you can bring. You can draft your story accordingly. You can build up your case. You have an edge. So maintain that edge. Don't take it casually and take a draft for someone and just copy it and send it. No, you must make it a point that you have all those things which can help your client. In the first meeting itself, you can guide your client to open a bank account in a branch which falls under the jurisdiction of the court of your practice, and further guide the client to deposit and redeposit the said check. Now, why do I say so? When a client comes to us, for example, this is a 138 NIA case. It could be a domestic violence case as well. Now, you know, when a client comes to you, what could be the proper jurisdictions for it. So you guide the client accordingly and you draft your case accordingly. And if a territorial jurisdiction which is near to your court can be done, for example, if I tell you in a domestic violence case, it would be the place of occurrence. But now it's a settled for a client which comes for alimony as well. Now the case can be filed where the lady is presently residing. It can also be filed at the place where they last resided together. It could also be filed at the place where they got married or the last resided place. So there are a lot of territorial jurisdictions. Now, if you want to enhance your chances, you are going to choose that jurisdiction, which will bring more matters to you and which will be good for your practice. So it is also into the hands of the counsel to guide the client and take the matter in a way. That's why I say the complaints counsel is the privileged master of his case. Now, if I can get 3 matters in a particular jurisdiction, that will help me. And that will be cost effective also to me. As a first generation lawyer, we have to be cost effective also. Now, post 2015 amendment, territorial jurisdictions in NIA cases has been absolutely curtailed. Yeah, that's I like we are running short of time, so I will jump a little steps, and I will try to guide you. What are the important points that we can keep in mind? Like for example, if I say law regarding negotiable instruments is a very dynamic law and keeps evolving through precedents. Now there are a lot of streams which keep evolving. Yeah, law is very dynamic, but there are a few. For example, if I tell you, if I talk about law of crimes, now in law of crimes there are a few settled propositions. Like for example, in a 302 case, there are only 2 punishments that are possible. Either it will be LI or it will be a death, capital punishment. These are the only 2 punishments prescribed. Now nothing is going to change with regard to it. So there are settled propositions. Punishment is same. Even as far as the appreciation of evidences is concerned, there are few settled propositions. But with regard to few dynamic streams, things change every year. So you have to keep yourself up to date and draft your legal notice as well as your petition in consonance with those judgments, right? The complainant's counsel has to remain over diligent in a check bounce case, as the appeal against acquittal by a complainant in a check bounce case lies to High Court, wherein leave of the court is compulsory. Now, when we are filing a case as a complainant, even in other complaint cases as well, we must keep in mind if you are filing a complaint case under section 200 CRPC, there could be a probability that we lose the case, and we must give our best efforts. Why? Because if it results into an acquittal, we won't be able to go to court of sessions in a magisterial case. We will have to go to High Court. So the client will be taken back, because in most of, apart from Delhi, most of the high courts are far away from the district courts. And once the client has to go to a different court, first of all, you lose your brief. Number 2, you may lose your trust as well. There will be loss of fees as well. So we must keep all those factors also into mind. Because what happens is trial court lawyers, especially first generation lawyers, we first generation lawyers don't have appellate practice or appellate briefs coming to us. We develop our trial court practice, and from that trial court practice only we develop our appellate court practice. 70% of the appeals that I have done by now are mostly in those cases only where I did the trials. The clients trusted me. We have suffered convictions. We have got acquittals. We have secured them. In both the matters, client had a trust, and they only said that you only do the appeal. So trial court first generation lawyers have to ensure this thing. Even if they are aspiring to go for higher courts or appellate courts in the further times, they must remember that their trial should be the strength, so that they may get the further briefs as well.